financial privacy through private banking relationships. For example, a professional association might keep its members' roster confidential, conduct meetings in private venues, and resolve disputes through internal arbitration rather than public litigation. This privacy isn't absolute, depending on the circumstance, but PMAs must still comply with applicable laws, but they maintain significant control over their internal affairs. Now, unless people are actually harming the public, that's a different story. But if you're not causing any harm absolutely whatsoever to the public, then none of this is an issue. All right? Trusts employ similar privacy mechanisms. The trust instrument maintains private documents. The fiduciary relationships that include confidentiality obligations, private trustee meetings and decision-making process. That's just the meeting minutes. Financial privacy through specialized banking arrangements, and in some jurisdictions, legal protections that shield trusts from public disclosure. All right, but that's why it's always best to have a private ecclesiastical trust, which is a trust owned by a church. So, for example, a family trust might keep its assets, distributions, like money or property, and beneficiary details entirely private. And you should. If you have a trust, these things are private. Nobody has to see them. If you have a private trust, not even a public court can impose or force you to reveal these documents. And these documents have information shared only among trustees and beneficiaries. The trust's affairs don't appear in public records the way corporate transactions do. International organizations like the UN and NATO enjoy even more formalized privacy and autonomy.